because I was in an argument with my boyfriend. I just found out he cheated on me. And so I left. I went to the Little Mexico because that place makes everybody happy. Go here and listen to everybody's stories and stuff, and maybe it'll help you in the future, like to not to do this or end up in this situation. I'm never going to do this again.
I need you to speak up so we can make sure the recording equipment's getting you, all right?
Yes.
All right. Will you please raise your right hand? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. So it's my understanding that you'll be pleading guilty to count number 2 of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $100 to $500 and or 360 hours of community service, rehabilitative programs, vehicle mobilization mandatory with a prior, and reimbursements for the cost of prosecution, governmental expenses. In exchange for that, the people will be dismissing count number 1 of operating with a high bodily alcohol content. That carries some of the same penalties as the operating while intoxicated, but it is subject to a misdemeanor of 180 days in jail and or a fine of $200 to $700. Is that your understanding of the plea agreement?
Yes, sir.
Now, do you understand that if this case were to move forward and go to trial, the prosecutor would not be able to try you on both charges? They would have to choose one over the other. Do you understand that?
Yes, sir.
Does that have any impact on your decision to plead? So what I'm asking is, I want to make sure that this is a valid plea and there's not essentially false promises made.
Oh, no.
So the fact that they would only be able to move forward on one of those charges, did that have any influence on your decision to plead today? Ms. Fairventle, do you want to maybe explain it better?
I do understand.
All right. And I want to make sure that you're not entering a guilty plea on the inducement that one of the charges is going to go away because it would have to go away anyways. Do you understand that?
Yes, sir.
All right. Back on February 3rd, 2026, were you on probation or parole?
No, sir.
Were you on bond in any other file?
No, sir.
Do you remember reading and signing an advice of rights form talking about your rights to an attorney and your rights to a trial?
Yes.
Ms. Fioravento?
May I approach,
You
Judge?
may.
I've presented Ms. Draper with the advice of rights form signed on February 4th, 2026 from the court's file.
Oh, yeah. Yes,
Do you remember that? Did you understand those rights?
I think so.
All right, I'm going to go through them with you just to make sure.
Good approach.
If you require accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you fully participate in court proceedings, please contact the court immediately to make those arrangements. Excuse me, do you understand that right?
Yes, sir.
You've been brought to court on a misdemeanor charge and the following basic rights: to plead guilty or not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered, and you may plead no contest with the permission of the court. To have a trial by jury and to have the assistance of an attorney. Do you understand that? You have the right to an attorney appointed at a public expense if you are indigent, which means without money to hire an attorney, and if the offense charge requires a minimum jail sentence or the court determines that it might sentence you to jail, the appointing authority will decide if you are indigent and appoint counsel if you are eligible. And Ms. Fioravento has been appointed to represent you. You may have to repay the expense of appointing an attorney, and you may contest your ability to pay the ordered fees if the court attempts to collect any costs for an attorney, and the court must determine your ability to pay at that time. Do you understand that? If you have a trial, you have the following basic rights: to call witnesses to speak for you at trial. You may get an order signed by the court to require witnesses to come to court, to see, hear, and question all witnesses against you, to be a witness for yourself or to remain silent. If you choose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. And the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes, sir.
If you plead guilty or no contest and your plea is accepted, you'll be giving up those trial rights that we just went through, and you won't have a trial of any kind. Do you understand that? Yes.
Yes, sir.
You also have the right to be released on bond, and that's already been taken care of. If you are now on probation or parole and you enter a plea of guilty or no contest, or a finding of guilt is made by the judge or jury, it may result in a violation of your probation or parole. You can be sentenced to jail and fines plus costs. The court will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, or both. Fines, costs, and other financial obligations imposed by the court are due at the time of the assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, contact the court immediately to request a payment alternative. An appeal to the circuit court must be taken within 21 days from the date of sentence, or is permitted pursuant to court rule. If the sentence includes incarceration, and if you wish to file an appeal but are financially unable to retain a lawyer, the court will appoint a lawyer to represent you on appeal if the request for the lawyer is made within 14 days from the date of sentencing. Federal law and or state law may prohibit you from purchasing or possessing ammunition or a firearm, including a rifle, pistol, or revolver, If you are convicted of a misdemeanor crime of violence and you are a current or former spouse, parent, or guardian of the victim, you share a child in common with the victim, you are or were cohabitating with the victim as a spouse, parent, or guardian, or you are or were involved with the victim in another similar relationship. Do you understand all those rights?
Yes, sir.
Do you have any questions for me about those?
I don't think so.
Well, now's your time.
No.
Thank you,
All
Your
right.
Honor. I consulted with my client. She has no question. She is quite young, and this is the first time she has been through this process.
No, I understand. Most importantly, do you understand that you have a right to a jury trial? And that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind.
Yes, sir.
Other than the plea agreement, has anybody promised you anything in order to get you to plea?
No, sir.
Has anybody threatened you in any way? And is your own free choice to plea today? Yes. Are counsel aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor. No, Your Honor. Thank you.
With Ms. Draper, to the allegation that on or about February 3rd, 2026 in Cherry Grove Township of Wexford County, how do you plead to count number 2 of operating motor vehicle while intoxicated?
Guilty?
Sure.
Guilty.
All right. In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on February 3rd, were you operating a motor vehicle in Cherry Grove Township?
Yes, sir.
And prior to operating that motor vehicle, had you consumed some alcohol?
Not until I got to the restaurant. And then when I left the restaurant, I was
Okay. So were you driving when you left the restaurant?
attempted to.
You attempted to. So what happened?
I did not do very well and I went into the ditch.
Okay. Were you driving the car when it went into the ditch?
Yes, sir.
And had you left the restaurant premises?
No, sir.
So you drove into the ditch into the parking lot?
Yeah.
All right. Ms. Lawrence, are there chemical tests to support the plea?
There was a blood draw and that came back at a 0.237.
Ms. Fiorvento, do you stipulate to its use for purposes of the plea?
Yes, we do, Your Honor.
Do the parties believe the defendants provided a factual basis in which to accept the plea and the court rules have been complied with?
Yes.
Yes, Your Honor. We ask the court accept the plea.
The court agrees. I find the plea is knowing, voluntary, and accurate. Ms. Draper, I find you guilty of count number 2 of operating while intoxicated pursuant to the plea agreement. Count number 1 will be dismissed at the time of sentencing. Counsel, I have received a substance use assessment this morning. Due to the law and the court activity, I had the opportunity to review it. Have both of you had a chance to review it?
Yes, Your Honor.
Yes, Your Honor. I've also reviewed it with my client as well.
Are there any additions or corrections we made to it?
I did catch one typo in the recommendation section, Your Honor, or appears to be some sort of typo. It just says prime for life. And so I'm not sure if that's a program that is being recommended. It is just in there between the other recommendations, and that is on page 3 of 3.
I don't know what that means either. Any objection to removing that, Ms. Lawrence?
No, Your Honor.
All right. We'll strike that then. Ms. Lawrence, do you have any additions or corrections?
No, Your Honor.
All right. Ms. Fiorvento, elocution.
Thank you, Your Honor. This is Ms. Draper's first offense. She is 21 years old, and she's taken responsibility for her conduct here. She was cooperative, it's my understanding, she was cooperative with the officers on the scene. She has not had any issues whatsoever while out on bond in this matter. She has voluntarily attended AA, and she has provided her 30-day tip and proof of attendance, which were sent to the prosecutor. I'm happy to forward those to the court as well. Her substance use assessment indicates that she does not have an ongoing problem, but certainly the events leading to this could warrant some degree of monitoring or probation. This is her pure first offense. She has no criminal history before this. In consideration of all of that, Your Honor, we would respectfully request fines and costs, or if the court would allow simply some short term of probation. She has shown that she is taking this serious through her actions and through her performance on bond and voluntary participation in services. Thank you.
Thank you. Ms. Lawrence?
Thank you, Your Honor. While I do understand her substance use assessment is rather positive, my main concern here is that she is only 21 years old and she's at a 0.237 and she's driving. I do think that is very concerning. I would ask the court to impose a period of probation. I will leave the length up to the discretion of the court. Thank you.
Ms. Draper, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
I learned a lot from this so far, and I'm never going to do this again. It costs a lot of money to be here that I don't have, and honestly, Now that I've gone to AA and like listened to everybody, I go there a lot. And I think that AA should be in like a classroom in high school or like an after school thing if you want. I think it's just good to go here and listen to everybody's stories and stuff, and maybe it'll help you in the future, like to not to do this or end up in this situation. You know what I mean?
So your assessment says that you first tried alcohol at the age of 18. You're 21 now. Your assessment's coming back that you don't have a disorder. So how often were you consuming alcohol?
Not often. I'd go out once in a while with my buddies and not out of it.
The assessment says that you consumed one shot of tequila and had one margarita. When was that in relationship to you driving your car or attempting to drive your car?
I was probably at the Little Mexico for, I don't know, maybe 20 minutes, and I just slammed on. And then I went to leave because I was in an argument with my boyfriend. I just found out he cheated on me. And so I left. I went to the Little Mexico because that place makes everybody happy. The food's good, drinks are good, you know. And I left there. I was in a little bit of a better mood. So maybe 20 minutes.
How big was the margarita? Because I'm sitting here with a shot of tequila and a margarita to get to a 0.23. It makes me wonder whether there wasn't more there that wasn't reported. I mean, that's.
No, that was it.
Okay. And I did not, looks like when you were arraigned, I did not order that you not use recreational marijuana. But I see in the assessment that you used marijuana up until March 1st, which would have been the day before the assessment. Had you continued to use marijuana?
A little bit.
Was that recreationally or medicinal?
Recreation.
So this is always something that's fascinating for me because one thing I'm always concerned with is somebody trading one substance for another. So let me finish. So if you were on a drunk driving charge and you're going to AA, why continue to use the marijuana?
At first it was like just like help me sleep, and I probably use it once a week maybe. But I go to AA a lot, and a lot of people are telling me just quit everything, just go to Jesus. So
I am also the sobriety court judge. And I've been on the sobriety court team in different roles as a defense attorney, as prosecutor, and now as judge since 2015 or 16. And I can tell you from my experience, I have to agree with what you're being told. Maybe not the religious aspect of it, because that's individual to everybody, right? But as far as leaving the alcohol and any mind altering substance behind, that's probably your best alternative here.
Okay.
Because what I am afraid of is, like I said, you trading one substance for another. So we start with the presumption in these cases that there's no jail and no probation. But that's a rebuttable presumption. And what I have here is I have somebody who's 21 years old, who is testing without a disorder, but whose bodily alcohol content, in this case blood alcohol content, was a 0.237, didn't make it out of the parking lot. And while stopped using alcohol, and to your credit, you've done everything I would have asked you to do, but we're still using the marijuana. So I want to give you some educational classes and so maybe get you on a path forward where you can put these substances behind you before it does become a problem. And so I do feel that a period of probation is appropriate. It's not going to be a very long period, just kind of enough to get you into the programming and maybe get you grounded a little bit. So I'm going to do a period of probation I'm going to do 8 months. During that period of time, you're not to violate any law, report is ordered, not leave the state without permission, and to keep your contact and employment information current. Now, this charge does allow you to be released early from probation. So if you've done everything that we've asked you to do at the halfway mark, or 4 months, you can be released. Now, if you think you should be, but your probation officer doesn't think you should, you can file a petition on your own. We'll have a hearing, and I'll make that determination as to whether or not you should be released. Does that make sense? During the period of time that you're on probation, I want you to attend the Alcohol Highway Safety Education class and the Victim Impact Panel. Not to consume any alcohol, no illegal controlled substances, including recreational marijuana. And you'll be subject to testing pursuant to the requirements of your probation officer. I also want you to follow the substance use recommendations. I can't, because this is a first, I can't order you into a recovery program, but if you find that beneficial, continue on with that. All right. I'm also going to order any programming for drugs and or alcohol, and any additional programming that your probation officer feels is appropriate. Now, what do you do for income?
I work at FedEx.
Okay. Oh, that's right. Part-time, correct?
Yeah.
All right. How many hours a week do you get?
Right now, not very many because Christmas just got over, but we should be picking up in a few weeks. I say right now about 20.
So do you load trucks or what do you do?
Yeah, I love the truck.
All right. How long have you worked there?
About 2 years now. On the 20th, that'd be my 2-year anniversary.
Okay. All right. There will be a $75 crime victims' rights fee, $50 state minimum fee, $150 fine. The court will waive the court costs. Attorney fees, Ms. Fioravento?
Waive if the court will allow.
We'll waive the attorney fees. I'm only going to charge you for the 4 months of probation, which is $120. If you end up staying longer than that 4 months, you're going to have to pay the monthly fee for that. Any reimbursements requested, Ms. Lawrence?
Yes, $200 to the Michigan State Police, as well as a $100 prosecutor fee.
In certain cases, law enforcement and prosecutors are able to recoup a portion of the expense in prosecuting these cases, and drunk driving's happen to be one of those. So that's what those 2 fees are for. So there's $100 to the sheriff's department, I'm sorry, $100 to the prosecutor's office, and $200 to the state police. 1 day jail with 1 day credit. Because you have sat 1 day jail, you're entitled to $5 back towards that fine. Is anything I've missed in a judgment of sentence?
No, Your Honor.
Ms. Fioravento?
No, Your Honor, thank you.
Ms. Draper, any balance that remains unpaid for more than 56 days has a 20% penalty added to that, but I'm going to waive that penalty while you're on probation. All right. Do you have any questions for me about your sentence today?
For the educational classes, other than that one, do you have like business cards or a phone number I can call?
So your probation officer will help you get set up for all that. All right. You can go out to the front window where you checked in, get a copy of your judgment, make a payment if you're able. If not, get set up on a payment plan, and then go downstairs to the district court probation office and get signed up for probation. All right. All right. Good luck to you. Ms. Draper, you can also turn in your SoberLink device to the Community Corrections Office because your testing requirements are going to change as well. All right.
Thank you so much.
Thank you.
Under Michigan law, the defendant entered a guilty plea to operating while intoxicated, governed by MCL 257.625, subsection 1. In exchange, the prosecution dismissed the more severe charge of operating with a high bodily alcohol content under MCL 257.625, subsection 1c. The court accepted the plea after finding it knowing, voluntary, and supported by a factual basis consistent with Michigan court rules on plea proceedings. Although this was a first offense, the court considered the defendant's BAC of 0.237, which significantly exceeds the statutory threshold and raises heightened public safety concerns. Pursuant to sentencing authority under MCL 257.625 and related probation statutes, the court imposed a non-custodial sentence of 8 months probation with eligibility for early termination after 4 months upon compliance. Conditions include abstinence from alcohol and controlled substances, mandatory participation in alcohol education programs, attendance at a victim impact panel, and compliance with random testing and supervision requirements. The court also imposed standard financial penalties, including fines, costs, and statutory assessments such as the crime victims' rights fee under MCL 780.905. This sentence reflects a rehabilitative approach, balancing the defendant's lack of prior record with the seriousness of impaired driving and the need for behavioral correction under judicial supervision.